Good evening, everyone. My name is Hiro Aragaki. I'm the director of the Center for Negotiation and Dispute Resolution here at UC Law San Francisco. And I want to welcome you to the 6th session in our ADR speaker series for 2023. We are extremely fortunate today to be able to have two real big thought leaders, incredible thought leaders in the ADR field, Jan Martinez and Colin Rule, who are really on the cutting edge of online dispute resolution, dispute systems design, and the interplay between the two. They really don't need any introduction, I would say, but let me just say a couple of words about each. So first we have Colin Rule, who is the president and CEO of Mediate.com and Arbitrate.com, and is really known the world over for all of his work in the ODR and tech space. Among his illustrious accomplishments, he was previously the director of online dispute resolution for eBay and PayPal, and co-founded Modria.com, an online dispute resolution provider based in Silicon Valley. He's trained and presented and consulted on ADR around the world and has received numerous awards, including the Frank Sander Award from the ABA. We are also very happy to have Jan Martinez, who is the director of the Gould Negotiation and Mediation Program at Stanford Law School, where she focuses her research and consulting on the lawyer's role in negotiation, dispute systems design, online dispute resolution, the facilitation of public disputes, and negotiation curriculum development for clients in the public, private, and nonprofit sectors. She is the co-author of Dispute System Design, Preventing, Managing, and Resolving Conflict, which many, including myself, regard as the Bible of the dispute system design field. So I think we're going to start with Colin making some remarks, and Jan may piggyback off them. Afterwards, we'll go for maybe 25 minutes-ish, if that's okay, and then open it up to Q&A. If you're joining us via Zoom, please do raise your Zoom hand because we can't see the comments box from where we are, so do raise your Zoom hand and we'll call on you as well. Those of you who are in person with us, please do join us for the reception, which will follow beginning at 6:15 p.m. Yeah? So without further ado, let me turn it over
I'll take it.
Oh, okay.
Thank you, Hiro.
Sure.
Hi, everybody. Thank you so much for having us. This is a real joy. Look at this beautiful space. My gosh, I love this. I'm glad it's not a couple months ago because it probably would have been dark at this point. But I'd like to thank you, Hiro, for inviting us. And congratulations on 20 years at the Center for Negotiation and Dispute Resolution. That's really exciting. So hopefully you're going to throw a big party. I want to first acknowledge my very good friend, Jan, and colleague. We've taught together. How long have we known each other, Jan?
32 years.
32 years, yeah. So I first met Jan when I was a grad student at the Consensus Building Institute. I was working there, and Jan was a senior fellow. So we started working out on public policy disputes together. And so I'm going to make a couple comments just to kick things off, and then I want Jan to weigh in. And then let's make this as interactive as it can be. Hiro, thank you for having us to your class. That was such a rich conversation. It was hard to end it, and I'm tempted to just pick up where we left off and continue. But let me indulge myself in a couple slides, and then we'll see where things lead us. So I'm going to start us in a weird place. Did anybody expect me to put up a slide of Marie Curie? I bet you didn't. So everybody knows about Marie Curie, right? I have a lot of friends who went to law school, and they joke, I went to law school because I wanted to get rich, and I didn't want to have to do math. So I don't know how many of you have a science background, but Marie Curie, obviously, she discovered radium, the element radium. And when this discovery was made, it was a revolution, a revelation. People all around the world started to talk about radium, radium. What's it going to do? It's going to change the world. This new element. They actually created dances called the radium dance. They had beauty products that had the power of radium in them. There was butter, radium brand butter, and radium cigarettes. There was even invigorating spa water from the radium spa, because nobody really knew what radium was. All they knew it was going to change everything. That's what it was. There was even, one of the properties of radium is that it would glow in the dark. So they would mix it into paint and then paint the numbers on clock faces with this paint so you could see it in the dark. And these women, obviously, who were painting these clock faces, they had a very fine point on their paintbrushes. So they would actually dip the paintbrushes in paint and then lick the tip of the paintbrushes so they could paint the numbers on the clock so that they would look good. So obviously, this is tragic now because we understand, how did Marie Curie die? She died of radiation exposure, and it takes time for the negative impacts of radiation exposure to be learned. So all of these things that we thought radium was good for, it turns out, no, radium was not good for those things. Now, radioactivity is useful for many other uses, but that wasn't what the dance and the spa water and the butter was all about. So why am I sharing this? I think that's kind of where we are with AI. I think we're at the radium stage. I think soon we're going to have AI dances, we're going to have AI butter, and we're going to have AI branded water, and we're going to have people like just AI everywhere. It's like, I heard, this was a rumor, but I heard that they've now started a new religion where people worship AI. So I hope that's not true. But I think that we're at, everybody talks about AI. I just heard, was it Little Mike? You said somebody's doing an AI presentation like tomorrow again. It's like the hot topic, man. There's conferences everywhere. It's on TV. It's in the newspaper, just like it was with radium. And I think that it's kind of a Rorschach test. I think when you look at AI, what you see says more about you than it says about AI, because AI is a very specific thing, and it's been around for quite a while. It's not like a lot of this technology is new. It's just we're having breakthroughs in terms of the public's access to it. So some people, when you say AI, they think Skynet, right? I don't know how many people have seen The Terminator, but this was the AI that they turned on. Actually, Skynet faked out the humans and pretended that there was an attack, and the only way they could respond was to turn on the AI, and there was no attack. And then, of course, Skynet decides that the humans are a problem and then creates all the Terminators to eliminate them. So some people, I mean, like Elon Musk just wrote this letter the other day that says we have to stop it. This is going to be terrible for humanity. Okay, that's the Skynet caucus. I actually think that AI is going to be this is not going to be our dystopian future, the Terminator. I think it's going to be WALL-E. You know, have you seen WALL-E, the Pixar movie? I know your daughter works at Pixar. So, you know, we've destroyed the planet. It's a mess. Humans have all gone up into this spaceship in the sky. And the computers just play us funny videos and bring us milkshakes, and we're just like kind of flesh balloons floating around on our anti-grav chairs. And you know, they just kind of get us out of the way. Why would they bother killing us? You know, we're not that hard to entertain. We were talking about this earlier. We're just the smartest monkeys. That's all we are. It's not that hard to entertain the monkeys. So maybe this is the future that awaits us. But another thing people talk about a lot is self-driving cars. And at Stanford Law, this was a big focus for many years. Everybody's talking about the law of self-driving cars. And I think this is very interesting because you can imagine a future 10, 20, 30 years down the road where we do figure out this technology. When Jan and I drove in today, there was a Waymo car right next to us on, what were we driving up? We were driving a 101, and there's a Waymo car. Now in San Francisco, it's not a big deal. They're driving around all the time. You know, I think I saw a video yesterday of a bus that comes up a street, and then a Waymo car like turns right in front of it, and the Waymo car is like, I don't know what to do now. And the bus driver's like, there's no driver. What do I do? You know, they have to wait for the Waymo people to come out, tell the car, it's okay, back up, it's all right. But I mean, one day, this is going to be normal. And every day when I listen to NPR, they have the traffic report. And they say, well, we have a fatal accident on the 280, you know, or there's a motorcycle got run off the road and on 880. And we're like, well, what can you do? I guess the traffic just has to have a body count. It's just the way it goes. I mean, you know, you get in a car, you take your risks. In the future generations will think back on this time and think, that was crazy. That was crazy that getting in a car to go to work, you're putting your life in your hands. And every day, somebody's going to die in an accident, but we just hope it's not us. And the computers are going to drive the cars. And the computers are all going to be able to communicate with each other. I mean, who knows? Hopefully, we're not going to do this until the technology really works. But the idea of cars crashing into each other and people dying in a fiery wreck, that will be ancient history. And the future generations will think back on our era as a savage, incredibly scary time. So what I'd like to put to all of you is, maybe we're going to get more comfortable with the idea of computers doing other things too, not just driving the cars. And maybe future generations are going to think back on our human-powered era of justice also as an unacceptably risky and dangerous time that generated enormous tragedy and created, you know, terrible outcomes. And maybe in the future, we can think of a way to use algorithms to avoid that type of system. So again, I don't know if any of you have seen Futurama with the robot judges, right? I love that it's still the robot judge with the wig and the robe, you know, like, do we really need, but there is something about that. There is that framing. And I can't tell you how many presentations I've done where people say, wow, you're going to build robot judges, right? And the robot judges are going to make the decisions. That's actually not what I've been working on for the past 20 years. It's about using technology to facilitate human-to-human communication. But now we have AI, and the question is this the radium dance, or are we going to be able to deliver on this? I think the technology is just a tool in the toolbox. You can use the tool for whatever you want. The tool will do whatever you tell it to do. You can use a hammer to, do Habitat for Humanity, or you can use a hammer to, build a weapon that's going to, kill the other side. The technology doesn't have a value. It's the person that uses the technology that has the value. So I love this quote. It says, there's nothing artificial about AI. It's inspired by people, it's created by people, and most importantly, it impacts people. So I think that people talk about AI as if, Jan and I, we do a class on online dispute resolution. We ask the students at the end to design an ODR system. And I've gotten a couple papers now where people say, well, we're going to build an ODR system with AI. People are going to put the disputes in. The AI is going to resolve them perfectly. And then everyone's going to be happy. And I'm like, okay, well, what actually is happening inside the AI? Like, well, I don't know about that, but the AI is going to work its magic and it's going to make everything. Maybe that's why we have a religion based on AI now, for that kind of faith. But I think it's very clear AI does something very simple. And essentially what AI does is it takes a large set of data, structured data, and then it has expected results correlated with that data, and it puts it into a computer that creates correlations in that data. It finds patterns in that data. And when you get a big enough set of data, it can come up with lots and lots and lots of correlations. So then, when you take that model, that correlation model that it creates, and you bring in a new piece of data, it can apply those correlations and make a prediction as to what the results should be. That's all AI is. Now, the question is, when you do this at a high enough scale, it starts to feel like, okay, wait a minute. So when we're interacting with ChatGPT, does it know what I'm thinking? How does it know that I want a milkshake? But really what it's doing is just this at scale. And what's changing over time is computing power and storage power. That's what's making these models more and more effective. There's something, do you know what Moore's Law is? Have you ever heard of Moore's Law? Moore's Law was coined by Gordon Moore, who's one of the guys who founded Intel. And he said in the 70s that computer processors were going to double in power about every 18 months. And actually, you know what? It's pretty much held true ever since. I think now it's closer to 2 years. Computer processors double in power every 2 years. Now, the amazing thing about that is that's logarithmic, right? And there's something called the singularity. That was coined by a guy named Ray Kurzweil. And he says the singularity is the point at which one computer processor exceeds the power of the human brain. And there's a lot of debate about when that's going to occur, but people think it's going to be sometime in the 2030s. So if you imagine that we're going to get to 2036, and then a computer power is as powerful as the human brain, if Moore's Law is still holding true, then 2 years later, a computer processor will be twice as powerful as a human brain. And then 2 years later, 4 times, et cetera, et cetera. So we're on the cusp of some huge breakthroughs in technology. Quantum computing, it's unimaginable increases in the power of computers. And all this mechanism has been in place. This basic structure for machine learning, we've known about this for decades. But now what's happening is the computers are getting so powerful, it's able to take this to unimaginable locations in terms of the power of AI. So I'm going to try and wrap this up quickly, but there are, one of the things that I like, actually I'm going to say this because Ron's in the room and he came from Google. I don't know if you know Cassie, but AI is a proliferation of a magic lamp. Unlike traditional programming, they allow you to solve a problem even if you can't think of the solution steps yourself. So I love this quote. It's not the genie that's dangerous, it's the wisher. And we are the wisher. When we talk to ChatGPT, we create the prompt. And ChatGPT will do its best to match that prompt. But we have to think about the wishes that we make. That is the power of this new tool. Okay? So let me give you an example. This is diabetic blindness in India. There are 70 million people who are diabetic and at risk of developing diabetic blindness, but the problem is there's only 11 eye doctors for every 1 million people. So there's no way that the doctors can go examine all the patients. So what did they do? They automated screening using AI, and they fed an AI algorithm lots and lots of scans of people's retinas, and they said, these are the people who are in danger of having diabetic blindness, and these are the people who are not. So what did the AI do? It created correlations based on that image data. And then what they did is they brought out these machines in rural areas, and they can scan it, and they can identify if someone's at risk of developing diabetic blindness, and then they can have someone come out and treat them. But this is an example of using artificial intelligence at scale for a medical application. So there's a lot of examples of this. There were researchers actually in Scandinavia that fed a machine learning algorithm millions of x-rays of human hands. And they provided patient data about all of the hands that were in the x-rays. So the machine learning algorithm was looking at these images and creating correlations and trying to find patterns. And what they found is when they give that correlation engine, when they give that AI a new x-ray of a human hand, and they don't tell it anything about that patient, the x-ray can tell to a confidence level of like 95% the race of the person whose hand it is. Now, the interesting thing about that is there's no doctor on the planet that can look at an x-ray of a human hand and tell you the race of the person whose hand it is. But the algorithm figured out a way to do it. And when you open it up, the algorithm, you look at the correlations, all the data that it's churned out, it's gobbledygook. You can't make sense of it because it's just way, way too complicated, and it's all in computer code. So we don't even know how the algorithm can do that, how the AI can look at an x-ray of a human hand and tell you the race. And this is an example of how AIs are going to start to comprehend patterns that are probably beyond the ability of our monkey brains to pick them up. And even if we ask the AI, how are you doing it won't be able to explain it to us because it's perceiving the world. Again, this is just correlations. That's all it is. It's doing it in a more sophisticated way than we are capable of doing it. Okay? So let me just make a couple other points. In applying all of this to the justice sector, Richard Susskind, who's the chief IT advisor to the Lord Chief Justice in the UK, he wrote a book called Online Courts and the Future of Justice. And in his section on AI, he says there are 5 key questions. Is it technically feasible? Is it morally acceptable? Is it commercially viable? Is it culturally sustainable? And is it jurisprudentially coherent? And I think the answer to all these questions is a moving target. Okay? The introduction of ChatGPT and what's happened with large language models over the last 3 months, this has been a watershed event. I remember the first time I saw ChatGPT, it felt to me like the first time I saw Wi-Fi, or the first time I saw an LCD projector, or the first time I saw an iPhone. I was like, wow, okay, this is an inflection point. We are never going to not have this technology. So that makes a big change in is it culturally sustainable? Because now people are wrapping their heads around this technology and saying, wow, okay, how do I feel about this? Is it morally acceptable? Is it commercially viable? Those things are changing all the time too. But these are the 5 questions we have to ask ourselves as AI rolls out in the justice system. I'm not going to spend too much time on this, but there is a case that went all the way to the Supreme Court, and this was in Wisconsin, is that right? Wisconsin. And it was an AI algorithm that was used, judges could use it in order to get sentencing guidelines in criminal cases. So this is after a verdict has already been made about guilt or innocence. They could put all the information into this AI, and it would give them a recommendation as to what the sentencing guidelines should be. Well, some people looked at the recommendations from the algorithm and said, those are too lenient. Some people look at the recommendations and they said those are too harsh, because it was just looking at the data set that it was fed and sort of, again, applying that correlation engine to new cases. So some of the advocates for the offenders said, we want to see the data that's being fed into this algorithm, because it was a private company that created this. And the private company said, no, we're not going to show you that. That's our proprietary data. And they appealed it all the way up to the Supreme Court, and the Supreme Court decided in favor of the AI company. Were you going to say something?
Wisconsin Supreme Court.
Wisconsin Supreme Court. Oh, it was rejected at the U.S. Supreme Court. Okay, right. They did not review the decision from the Wisconsin Supreme Court. But again, this is a tricky thing, right? Because this is a black box. All this data that's being fed into this algorithm, it may be biased, it may not be biased. But now this private company is saying, well, we're not going to show it to you. So all you can see is the outcomes. All you can see is the recommendations the engine generates. So that can't be a blueprint for the future of how AI is going to be rolled out. Because an algorithm is an opinion embedded in mathematics. And algorithms are neither good nor bad, but they are certainly not neutral. This is what we were just talking about. And I think these books, Weapons of Math Destruction and Automating Inequality, they make an excellent point. If we take the injustice in the existing system and then we automate it through algorithms, that gives us the ability to deliver injustice at a much higher efficiency than we ever had it before. So it's not just a matter of taking what we currently have and automating it. I think we have to rethink these systems in a very basic way to tackle these problems of bias. So I'm not going to talk about this. I'm not going to talk about that. there's a lot of interesting stuff in here in terms of building data sets. There are a lot of companies that are building large data sets of dispute resolutions. This is the program on negotiation at Harvard. They're building a data set with negotiation outcomes. And there's a lot of ways, I think that we can utilize that data moving forward. There's a reason why Facebook doesn't let you pay a subscription, because you're the product. Their customers are the advertisers, and you're the product, and they want your data. They don't want your money. Your data is more valuable to them than the money. So that's something to think about, is the value of data moving forward. But let me just talk about this. I want to talk about the fourth party, and then I want to give the mic to Jan so she can react to some of this too. In dispute resolution, the father of online dispute resolution is a guy named Ethan Katch, who's a professor at UMass Amherst. And he wrote a book called Online Dispute Resolution in 2001, where he coined the term the fourth party. So if the disputants are party 1 and party 2, and the human neutral is party 3, technology is the fourth party. And the fourth party is your partner. There's a lot of things we ask the fourth party to do today. Send out reminders, send out calendar reminders, manage all of our documents, handle the invoicing, handle the billing. All of this stuff would have sounded like science fiction in 2000. And now it's just commonplace. Of course we would rely on technology to do all that. But the question is, it's less what the fourth party does today, all these things that we're comfortable with technology handling. Because at the beginning, we were reluctant for technology to do these things. And now it's like, well, of course technology is going to handle all of this. The question is what technology will do tomorrow. What will the fourth party do? Will it do research in our cases? Will it help us evaluate our BATNA, our best alternative to a negotiated agreement, and find our ZOPA, our zone of potential agreement? Will it coach us? It's okay, we're going to do a good job, don't back down. Will it help us reframe our cases? Will it help us enforce our cases? If code becomes the law, then we can automatically enforce these outcomes. And then would we even empower agents to work on our behalf? Instead of getting a human lawyer, we can get an agent. We give it all the data, and it goes off and tries to get us a resolution. But then we're the ultimate decision makers as to whether or not we accept or reject that resolution. So what I'm going to say, the last thing is ethics, AI ethics. And Jan and I have been very involved in the creation of an organization called ICODER, the International Council for Online Dispute Resolution. And there's been, more than a decade of work on ethical principles and ethical standards for online practice. It can't just be about dispute resolution service providers. It also now has to be about the coders themselves. So I do urge you to come to icoder.org, and you can see all of the standards. We've applied them in a bunch of different contexts. And this is too small to read, but we've put a lot of stuff into these ethics about AI, because we've been having a lot of meetings. We're doing a big meeting next week on the future of mediation and artificial intelligence, where we're calling out some of the ethical, you can see, equality, fairness, impartiality, legality, security, transparency, etc. But there are also international organizations that are looking at the application of AI in the justice system. And I think the CEPEJ did a very good job in putting together this report. And they talk about several principles around the use of AI in the justice system: respecting fundamental rights, non-discrimination, quality and security. Data security is really important. Transparency and impartiality. But this one I think is very important, that AI always needs to be under human control. And this is what we were talking about in the class too. You can have algorithmic resolutions, but I think they need to be instantly reviewable by humans. There needs to be an auditing process through which there's transparency around these algorithms so that people can come in and they can see how they're coded and the data that they're being used. So the example in Wisconsin is an example of how things can run off the rails if all this data gets proprietary. So what I would say to all of you, and I want to open this up to Jan to apply a more systems design conversation about this. This is still very unsettled, very unsettled. No one, not one professor in this building knows what the law is going to look like in 5 or 10 years. Every industry is going to be transformed by technology. Already has been. If you look at finance, you look at medicine, you look at entertainment, they're unrecognizable to what they were 30 years ago. The reason why the law has been slower to change is because it's a monopoly. It's protected. It's not subject to the same competitive pressures that make all these other industries change so much. And lawyers say to me all the time, am I going to lose my job due to AI? And I say, well, maybe. More likely, lawyers with AI are going to take cases away from lawyers without AI. But if you think about finance, there used to be a lot of jobs with people on the floor of stock exchanges holding up pieces of paper saying, who wants to buy 1,000 shares of IBM? And all those jobs are gone. But there are more people working in finance now than ever before. And what are they doing? They're sitting in cubes, and they're telling the computers how to make trades. And if you want to know what the future of the law looks like, it's going to look like that. It's going to look like us writing prompts for AIs. They're going to be writing tax shelters and contracts and all that stuff. So I'm not saying that legal jobs are going to go away, but they are going to change. And I'll leave you with one thought from my old Texas grandfather who always told me this when I was a kid. He said, Colin, don't build your business where the highway is, build your business where the highway is going. And when I meet lawyers and law students who say, well, I'm just going to get a job and go work at some big firm and I'm going to do the old thing. Well, that's true. Those jobs aren't going away in the near term, but that slice of the pie is going to be shrinking. So I think all of you need to think in a very creative way, learn about these things and figure out how do we build a new system that achieves the objectives that we have, that aspirational goal of the blindfolded woman holding the scales. We can achieve that with these tools. They're just tools. But it's going to take a lot of work for us to get it right. And there's going to be a lot of curlicues and bumps in the road between here and there. But I think if we do it right, we can use these tools in a way that expands access to justice and reinforces the values we have in fairness. All right, Jan, let me give you the mic and see. What do you think about all of that?
Thanks, Colin. Good afternoon. So, as Hiro kindly mentioned, I've been thinking about system design when you have conflict and you have more than one isolated incident, and so you have a stream of disputes. Is there a systemic way to approach those disputes in a way that is going to be more effective and more advantageous to the legal infrastructure and society? So thinking about, and as lawyers, we often are going to be faced with a client with a single dispute. And we might ask the question, are there more like this coming down the pike? And what could we think about in terms of making the system more effective and more helpful? So I have thought about this, come up with my co-authors on a framework for thinking about different aspects of system design with disputes, thinking about what are the goals, what are the processes we could use, what is the context? Is this an urgent matter or is it a slow growing? Do we have resources? If we build a wonderful system with all the AI, do we have the money to train people to use it? Do we have the capacity to and resources to make it work and be effective? And looking at evaluation, thinking about how do we know if we did a good job? So I think applying in a parallel with Colin's comment on AI is AI then becomes a tool for the goal. Is the most important goal in terms of the court, the number of cases and how efficiently they're handled? Or is it an opportunity to have voice? For some people, in some disputes like Katrina or 9/11, it would be really important to have voice, an opportunity to be heard. So the AI, I think, feeds into this at a couple levels. One, it helps deliver the goals. Do we want a more efficient system in our court? It can help us in terms of process, that you can tap into the AI and it'll give you predictions and thinking about what does a good outcome look like. And then it also is the experience of having your result, your dispute result. So thinking about how AI matches, and so I think when Colin and I have talked about this and thought we can build all this data set, we can have I was just talking with Alexis over our break, thinking that now we not only have the capacity to predict what will happen based on the AI and what is most likely to be the outcome, what is a fair outcome according to the California Civil Code. We can match in now. You can have a therapist who can help you think about your life situation and whether that can be helped in some way. And so you don't even necessarily have to talk to a human to get your therapy. You can maybe talk to a bot. And there was an article, I think it was in New York Times this week, talking about how that was effective. People found that they felt heard, even by the bot. And so I think the data that we are gathering and the uses we can put it to, the goals, whether we're looking for a quick system or a responsive system or a human voice or what combination of machine learning and human we want in terms of setting the boundaries of our legal system. So I think that's enough just to raise the main point, thinking in terms of systems and not just in terms of singular disputes, and thinking how you can tap into the data and the predictability that AI offers in terms of the technology, and who decides. Where is the power for designing either the system and or the individual case in itself? So let's open it up to some questions, either on AI or a little bit on systems to the extent it catches your fancy. Yes.
What's
Ron.
Any of your predictions in terms of timing for certain aspects of the resolution process? You know, we've looked at maybe assisting with some third party, you know, for an agreement using some of the language models, or, I mean, one could imagine within certain domains being able to help suggest resolution parameters. I don't know.
I mean, I think one of the aspects that Colin's been working on is putting at the front end when he was working with eBay is trying to diagnose what is the situation here. And I think that's, and also during class, we were talking about dealing with disputes that have already been filed, but we want to move upstream and find out what were the inputs for getting that dispute and how might we think about it earlier in that process. So I think that's exactly right. We want to be anticipating where the problem is coming and what are the options and then who makes that decision. So if you want help in diagnosing, I think this is where data is really useful in saying based on these inputs, this is the likely outcome. Here are the options. You can do it in family law in a divorce case. Here are some options how the children in shared custody was developed. Or here are some paragraphs that fit into a settlement agreement on property with some other cases. So there are a lot of valuable inputs that can be pulled in the diagnostic phase as well as the facilitating mediating phase when you, again, could use alternative. Colin, do you want to?
Yeah, I would say, can you hear me?
Yes.
Yeah, okay, great. There's a lot that's already happening in terms of the use of algorithms to help people resolve their disputes. I think right now, these large, should I use that?
Yeah, oh, you're fine.
Keep it, I think I got one. These large language models are kind of like the bright, shiny object, and people don't really know what they mean down the road. I think, you know, we're doing a lot of experimentation now and discussion about what does this mean for the dispute resolution process. Maybe if a mediator has access to one of these large language models, they could ask questions about, you know, could you create a settlement agreement, you know, for these two parties that memorializes these deal terms, or, you know, could you, you know, generate an opening statement that you know, that takes into these things into account. But, you know, as Jan said, in the family context, we already have in California something called DissoMaster, which is really just a big complicated Excel spreadsheet. And, you know, you can go in and put a lot of data points into DissoMaster, and it'll tell you this is the range of appropriate child support, and this is the range of appropriate spousal support. So we have, you know, at eBay, we did a lot of things with algorithmic resolutions, as Jan mentioned. What kind of problem do you have? Well, here's a comprehensive list of problems. Well, I have problem number 8. Okay, well, here's 8 solutions to that. Do you want a full refund? Do you want a replacement item? Do you want a partial refund? Well, I would take solution A, a solution E, and solution G. And then you can customize those solutions too. And you contact the counterparty. Hey, this person has this problem with you. They're willing to accept these solutions. Do any of these look okay? One of the things you can say in a small claims dispute, for instance, in the systems we build in the courts, we say, how much money do you want to resolve this case? Well, I want $5,000. And we say, okay, confidentially, what's the lowest amount you'd accept? And we're not going to tell the other side. But, you know, what was your well, I'd accept $3,500. And then you contact the counterparty and you say, okay, this person has this issue, here's their evidence, and they're looking for $5,000. Are you willing to pay that? No, I'm not willing to pay that. Well, how much would you be willing to pay? Well, I'd pay $4,000. Instant resolution for $4,000. So there are a lot of algorithmic mechanisms that are not based on AI. A lot of it's just basic arithmetic, but they're structured processes. Jan and I in our class, we do an exercise in a class action case where a bunch of employees, thousands of employees, got exposed to silica dust. And you have to create a calculator to figure out how much of the $500 million settlement does each member of the class get, because they all have different severity levels and they're different ages and they work for the company for a different period of time. I don't know if you've seen that movie Worth about Ken Feinberg, you know, who had to figure out all of the settlements for 9/11 and the BP oil spill. You know, that's what a lot of what they do is you create a calculator. And you have to figure out, okay, this is going to apply the same criteria across all the cases. That may be a fairer outcome than bringing individual disputants into an arbitration and having them argue, because we know then other factors factor in, like implicit bias and other things that may create, you know, imbalances between all the parties. So we already have a certain level of technology in the justice system. The question is, what is AI going to do? And as these cultural norms shift, as Susskind talks about, what is the expectation going to be of parties? If you have third graders that are going into Microsoft Word and hitting generate, generate, generate with the Bing button, they're going to expect that their lawyers have that. And a lawyer that can generate agreements like that, they're probably going to be able to turn out a tax shelter in a couple hours, where somebody that's doing manually, typing it out, it's going to take them 3 days. So we have to realize that society is changing. This technology is going to change society, and that's going to change the expectations of parties, and that's going to have to change the practice of the law. We don't really know what it looks like, but I think there are near-term areas where these things can add value so we can learn from them. And if the AIs are watching us as they get more powerful and computers get more powerful, if they're watching the data, they can learn, and the correlation engines can get more and more sophisticated, and then eventually they'll be able to deliver more value. So I don't know, Ron, does that answer your question?
I was more certain in what you're projecting in terms of, which is hard to do, when these things might roll out or which components.
I think you're going to start to see AI tools roll out in the next couple of years. If you see how many Y Combinator startups are now focused on using AI to like automate customer service and automate all this other stuff, I think you're going to see that a lot. But I think that, you know, the digital arbitrator, digital mediator, you know, systemic use of AI in the justice system, I think you probably got 10 years. I'm thinking 10 years before it starts to become more of a factor. That's a long time in technology. At eBay, if you ever made a projection beyond 4 years, they would just write you off. They're like, we're going to have flying carpets in 4 years. Don't make a projection 4 years out. So it's always a dicey thing to predict the future. I'm saying 10 years. If you look at the last 20 years, how disruptive it's been with the advent of social media and all this stuff, the next 20 years are going to be way more disruptive. Way more disruptive. The stuff that's coming down the pike, we have not even begun to think about how disruptive this stuff is going to be. Yes, please.
I had heard it, I don't really know much about it, but there was a Pew Charitable Trust group of studies in perhaps Florida,
right,
in the courts,
yeah,
using some more advanced programs, and I believe they were measuring satisfaction of the users and the court administrative personnel. Do you know anything about that? I didn't follow up on that.
You want to talk to that?
Go ahead. Yeah, there were 3 studies, I think, Arizona, Florida, and...
I think they were studying a court in Florida, but I think the teams were Harvard Zeta J Lab and then University of Arizona and UC Davis were the 3. But yeah, it was a Pew-funded study. A lot of ODR providers like me, we track satisfaction data, and companies track satisfaction data obsessively. Most companies use a metric called Net Promoter Score to track satisfaction, and it's just an industry standard. That's whenever you get that question, like how likely would you be to recommend this to a friend or family member? Yeah. That's what they're doing, is they're tracking satisfaction. And there are a lot of studies that show that question gets to core satisfaction better than just, well, are you happy with what you got? But you're right. What we have to do in the courts now is longitudinal studies by academics who can look not only at immediate outcomes and satisfaction with those outcomes, but also the longitudinal decision durability of those outcomes. Because, you know, if we're just delivering a lot of quick online resolutions and those things melt down after 2 years and people are back in court, and it turns out the old face-to-face process decided a case and it stayed decided for 10 years, that's what we need to know. So that's what Pew is funding, is those academic centers to do that longitudinal research to really evaluate apples to apples the decision quality of online mechanisms.
Is what I had heard, and again, this is all hearsay in my mind, was that the users actually liked it quite a bit.
Yeah.
The litigants, but that the administrative systems of the courts had a really hard time transferring their established systems over to some of these new ways of doing things.
Totally.
that's a gross generalization. But.
Well, I have a lot of firsthand experience with that because I've built a lot of ODR systems in the courts. I think there's something like 90 court-connected ODR systems in the U.S. now.
Right.
And I'll tell you, I've gone into offices with court administrators and you say, well, we've automated your scheduling. And they go, no, you can't do that. You cannot do that. That's my job. I've done that for 30 years. You cannot automate the schedule.
So institutionalized and entrenched.
Right. There's an Upton Sinclair quote that says, it's almost impossible to get a man to understand a truth if his paycheck is dependent on him not understanding that truth. And there are a lot of people in the courts that have that orientation. Like, no, you cannot automate this. So the real resistance is not technology. Technology moves fast, but people move slow. And I think that that's where a lot of the reticence comes. One of the things we found looking at ODR systems is people actually have higher satisfaction numbers with human-based processes than they do with automated processes, slightly higher. But the preference numbers are off the charts for ODR due to the efficiency and convenience. And you can imagine if you have a face-to-face mediator, and she's lovely, you know. Stephanie was fantastic. She helped us out, and, you know, what's your rating? Oh, 10. Give Stephanie a 10. Or if you have some algorithm that comes in, you're like, well, you know, wasn't that great? So maybe that would account for some of the inflation. But the convenience numbers are what's driving this. And the courts are implementing ODR at a breakneck pace because they're having a hard time keeping up with their case volumes to begin with. So if you can take an online mechanism and create these online meeting rooms as part of the process and you work out 60, 70, 80% of the cases, that looks good on their baseline metrics, and it gives them more time to focus on the cases that most merit their human attention. So I really do feel like efficiency is driving a lot of the adoption here, and I'm glad that Pew is funding these longitudinal studies because we have to make sure that we're having as good, if not better, outcomes through these mechanisms, not just faster. That's what you said too about efficiency versus equity.
What do you think about the role of lawyers in the online processes? The customers and parties, litigants, may prefer the speed and the efficiency and the transparency of what's going on, but how are lawyers feeling about this in your experience?
Well, you sure you want to ask me this question?
Yep. You go hang out at these meetings, so I know that you get an earful.
Well, I think, you know, Shannon Salter, who is the head of the Civil Resolution Tribunal in British Columbia, which is the most advanced ODR-based court in North America. I was at a Bar Association meeting where she presented, and she went farther than I go. She said, if you have a job that's based on inefficiency, you should not have that job. That, you know, if your job, if it only exists because it's inefficient, well, we should make the system efficient and we should get rid of that job. And a lot of lawyers in the audience were looking around going, oh, yeah, my job is based on inefficiency. So I do think that there are ways to evolve the practice of the law, and I'll come to you in a second, Hiro. You know, I believe the biggest victim of the billable hour is the lawyer. I think it's a really rough life to lead where you have to account for your time in 8-minute increments. I think it sets the interest of the lawyer against the interest of their parties. And I think that's well documented. Lawyers have really bad mental health because there's so much pressure to generate more billable hours. I just think that model is broken. It's broken for clients and it's broken for lawyers. And I hope that the automation is going to change those equations because there needs to be a better way to charge for services. If you deliver good services, it shouldn't be based on how much time you spent delivering that service. It should be based on the quality of the service you deliver. So I like flat rate, you know, I think is a possibility. I think there should be incentives for attorneys to do things faster, you know, because that's what clients want. You know, if you can use an AI and you can turn out a complicated commercial agreement in 3 hours as opposed to 3 days, well, why wouldn't we want to do that? But lawyers have an incentive to not do that. So, you know, I think that the practice of the law is going to change in some significant ways. My father was a corporate litigator, and by the end of his career, he was getting paid $650 an hour to just give his opinion about things. And it's hard to compete with an AI that can read 10 million articles in 16 different languages and give you an opinion. No matter how good a lawyer you are, it's going to be tough to get paid that much for, you're just a human expert system, and the computers can be a more expert system than you. But you need somebody to hold your hand, you need someone to listen to you, you need someone to tell you it's going to be okay, and AIs can't do that. So hopefully it's going to free us up to be more human. In the 80s, everybody thought technology was going to dehumanize us. We're all going to become automatons. The opposite has happened. Technology's taken all of the rote administrative tasks away, and now we are as messy and as human as we've ever been, if not more messy. So I think there's going to be more of that. But clients are messy, and lawyers are messy, and let's be messy together. And then the AIs can handle the documents in the background. Hiro, what were you going to say?
No, I'm just reflecting on this kind of brave new world that you're painting here that's really quite frightening.
You just need some Soma, and then you'll be fine. I don't know if people have read Brave New World.
My question, I guess, is related to what you're just saying about the lawyer's role. So what should students be thinking about now in law school? What should law professors be thinking about in terms of courses that are going to be relevant in the next 10, 20 years? So are you saying that maybe
Dispute systems design.
more
Upstream, okay.
more skills-based classes, rather than doctrinal classes? Because if you can just use ChatGPT to get the right legal answer, why do you need to pass the bar? Right? So should we be focused more on clinical or skills-based education? Should we be learning computer programming? What are your thoughts about legal education, the future for teaching and learning in this space?
Jan, you go first.
Okay. I think there's not one answer, and I think it depends where you are. Your geography, the type of dispute that you're having. And we talked quite a bit in class about moving upstream. So not waiting for the dispute to manifest and present itself and say, fix me or fix the problem, but to anticipate, yes, people are going to get divorced. Yes, they need help in sorting out what that agreement looks like. Eviction cases in San Francisco, there have been some really innovative systems, dispute resolution systems designed here that can process more of the data and the cases in a way that's more efficient. So I think be more local focused. Think about what are the disputes in this place, this town, these people. What do they look like, and what are they looking for? And I think working at that local level, then you can grow it up. But I don't think there's one answer. I think it's going to vary.
Yeah, I just want to weigh in on that too. I think that I was slamming MBAs before, but one of the things I like about business school is all they do is give you some skills, like here's how you write a business plan, here's how you do marketing, here's how you do double entry accounting, and then they're like, go invent something. We don't know what the future is going to look like. We can tell you what we learned. We can tell you the businesses we built. But a lot of those businesses are dead. They'll never exist again. So you have to go figure out what the business is going to be. And I like that entrepreneurial orientation, and I think legal education needs to be more like that. It's like, look, these are the lessons we've learned about procedural justice. This is what we've learned about building a fair system. This is what we have learned about rules of evidence. Go invent something, I really do think that your students, the people in this room, are going to have to invent a lot of new systems, and a lot of legal education is backward-looking. It's like memorize these cases.
Well, it makes you wonder, sort of, why do we need to learn how to brief a case if we can just ask ChatGPT to do that for us?
Well, and I remember when I was...
Right there with you.
There you go. There you go. And they got a lot of briefs they still have to write.
Do you have any hands raised on the Zoom? No?
Sure.
Yeah, Alexis.
I have a question. So you mentioned that study where you had the satisfaction rate versus the AI making decisions and a mediator.
Yep.
Was there any that had a mediator who was a non-lawyer versus a mediator, like you're not a mediator yourself?
Oh, yeah.
And so, like, what did that show?
Actually, that study was all non-lawyer mediators.
Is there any
Yeah.
that have lawyers? Is that satisfaction the same, or is it like?
I don't know. I haven't seen a study of lawyers. I will say there's some really interesting, again, this is one of the things that Ron talks about, data. Data is fascinating. One of the things we found at eBay is that people were happier if they lost their dispute quickly than if they won their dispute and it took a long period of time. And that long period of time at eBay was 12 days. If the resolution took longer than 12 days and you got all your money back, you were more frustrated than if on day one we had just told you, sorry, you can't get any money. Now, why is that? It's because it just goes on and on. They're asking you for more data. And I think the court process is often focused on we have to get to the right result. It doesn't matter how long the process takes. If it's endless appeals and endless evidence, we're still getting to the right result. How many courts will get you anything in 12 days? I mean, even a response.
Also, the problem is, what is the right result? Like, if you have a lawyer in the room, I'm not a lawyer yet,
Right.
but on my way, like, we've been trained that there is, like, a law, that you're going to apply this law as right and wrong. If you don't have that training, I see mediation as way to be way more creative and think of things that are not necessarily binary like that.
Mm-hmm.
Absolutely.
So you get more satisfaction, but then how does that impact AI too?
Well, I mean, you're doing this at CPUC, right? When you design a dispute resolution system, it's not about right or wrong. I mean, for me, as a mediator, it's never in the evidence. The answer is never in the evidence. The answer is in the parties. They know what they think is fair. So is it right that every case comes out at the same number? that has the same fact pattern? Or is it okay for different people to find different resolutions based on their own needs? I think that parties own the case when they're in the negotiation phase, and that's good. I think different people can come up with different resolutions. So I think that, you know, as I say, the justice system, the legal process is one dispute systems design. And for certain cases, it's the right dispute systems design. But I never wanted to sell technology to the courts. I wanted to buy all bulletin boards outside of every court in the United States that said, don't go in there. Come to ODR.com. It's better for you. It's faster. It's just as enforceable. It's more coherent, and it's going to empower you. That's what I want. That's my aspiration. Because as I say, there's a lot of cases that are made worse when they get into the law, not better. And looking to the evidence is a very, very work intensive. If you think that access to justice means access to lawyers, you're never going to be able to solve the vast majority of cases. It just generates a lot of busy work, and I just don't think that's the path. I'm more of a restorative justice guy. If the parties can work it out and they feel okay with it, well, then that's great. That's the way most cases are resolved anyway. And then so... I mean, there's a great article by Owen Fisk called Against Settlement. It says everything should go to trial because it doesn't benefit the law unless it goes to trial. If 98% of cases get resolved, then, you know, it doesn't benefit the law. It's like, to me, that is insanity. That's insanity. But anyway.
But as you said, you're not a lawyer.
I'm not a lawyer. That's right. I still don't know what a tort is, and I'm proud of that. Something about a harm. I don't know. But any other comments, questions? Thoughts? Are you terrified by this, or are you enthralled by it? I guess that's the Rorschach test, yes.
No, I really like all of this, but just from the data collection standpoint and kind of feeding the model, have you found that the confidentiality rules in court or about settlements have kind of hampered some of that collection, or have you found a way around it?
You mean like these non-disclosure agreements and things like that?
Yeah, or like the confidential settlements, like say, you know, some sort of dispute, but it's mostly confidential settlements. Like how might you try to peek into that or something?
You want to talk to that, Jan?
No, go ahead.
Well, it's interesting because I just had a call today with Imre, a friend of ours at Loyola, talking about, you know, I love, my younger son's name is Alexander David Rule for the initials, okay? So I love dispute resolution. I think there's a lot of, I know, it's cheesy. And if he was here, he would roll his eyes so hard he'd fall over backwards, okay? But too late, I was his dad, I got to decide. But the point is, I believe in dispute resolution. I think we can build systems that deliver justice. Actually, I've always been reluctant to talk about justice. I talk about fairness, fast and fair resolutions. Now, what you're saying is, one of the double-edged swords in dispute resolution is confidentiality. And we know there's a lot of abuses, particularly in these pre-dispute binding arbitration clauses with class action waivers. That turns my stomach because I do feel like that is a perversion of dispute resolution. I think it is designed to annoy consumers so they don't pursue redress. Now, that said, I'm not a throw the baby out with the bathwater person. I don't think we should go back to the bad old days of mass claims because, you know, I wrote a book and I printed in the book a 1 penny check that I got as a class action settlement. It was actually rounded up. I actually got 0.64 cents. They paid 44 cents for a stamp to send me a 1 penny check. And they're like, justice is done. And of course, the lawyers that certified the claim against eBay, my employer, I didn't opt into this claim, they made $36 million. Okay, so we can talk about the problems with that old mass claim system. But as you say, there are a lot of abuses with these pre-dispute binding arbitration clauses in consumer agreements and in employment agreements, especially when you have these non-disclosure agreements. So you can have a business that's systematically, you know, denying wages to hundreds of thousands of their employees. Only 10% of them actually file an arbitration, and they don't even know about the other people in the class. So other people may be having their wages stolen, they don't even realize. And they don't know that if they filed an arbitration, they would be eligible for that award. And again, most of these arbitration agreements, the consumer looks at it and says, well, I'm not going to do that. I'm not going to pay $1,000 to the American Arbitration Association on the chance that I win, and then I get the fees reimbursed. So what we know is consumers don't pursue redress. So there are plenty of abuses, but I will also say that the public aspect of the legal system is also a double-edged sword. And there are lots of harms that come from that public system. And you think about people who are re-traumatized in the courts and who have to confront the people that victimize them. And sometimes private redress is a much better process. So you know, I think these are design questions. These are the systems design questions. And, you know, when I was at eBay, I said, well, let's just be completely transparent. Like domain name disputes, there's something called ICANN, has a UDRP, the Uniform Domain Name Dispute Resolution Program, 100% transparent. You can see every filing, you can see every complainant, you can see every outcome. And that's great. That's procedurally, that's a good thing. When I started at eBay, I said, let's do the same thing. Let's be 100% transparent. And the powers that be in the C-suite said, oh, no, we're not doing that. We're not going to reveal all our secrets so that our competitors can make hay out of all of our disputes. We're going to keep this quiet. Now, I did work hard to build a fair justice system, and I think we did a good job. I had a lot of sellers say it was biased towards buyers, and I had a lot of buyers say it was biased towards sellers. Okay, I'm doing something right, because it's not like it's tilted in one way or the other. But I did design a confidential process. I did design a private process. You could not download all the data about all the disputes that we resolved at eBay, even though I originally proposed that we do that. So it's just, that's an element that you have to figure out. You got to balance it in every systems design. So I don't know if that sparked any thoughts.
Yeah, and I think to your point is it really illustrates the trade-off between confidentiality as one goal and transparency, and who decides, and is there a range of choice that the disputant can make, or is it going to be imposed by the system?
Great question.
So we have time for a couple more questions.
I do want to point out that Ron Dolan in the back of the room is a Hastings alum, and he has written a lot about this, legal tech, and he has recently joined Mediate.com as our Chief Innovation Officer. So he is a great resource if you want to talk to him about where all of this is going. He's teaching me this stuff every day, and I'm sure he's never seen my AI presentation, so I can't wait to get an earful about, oh, what are you saying? This radium stuff is nonsense. But he's another resource that I urge all of you to take advantage of. But Ron, do you have any comments or thoughts about this that you want to weigh in with?
Nothing's coming to mind. I think
It's law school, so I figured I could cold call you.
Let me see if I can. I'll do a question, Colin.
Oh wait, let's do. I think Ron has one thing he wants to say, and then we'll go to Hiro. Yeah.
I think that I have a different perspective of lawyers and the legal system than you do.
You do.
And I know sometimes you're being provocative.
I am.
Which is great. But I think that the interplay and the balance is worth considering the nuance. And the role of the legal system at the end of the day is to be the supreme arbiter of disputes. And at the end of the day, any disputes that you're trying to resolve outside the legal system will always be subject to constraints and rules imposed by the legal system.
That's true. It's a good point.
That's more difficult internationally, and that's also done, by international agreement, et cetera. So I don't think it's that as easy as I'm making it out. But I also think that we think we're doing better quality when we take a long time as lawyers. And what we see by the application of technology is we make it much more efficient and the quality goes up. And the problem is we never measured the quality when it was not with technology.
Right.
And that technology forces the imposition of metrics that shows us that with technology is actually better. And we're not going to measure it against the perfect when we use technology, but not measure it when we're just doing like human one, right? So. Yeah, but I think there's a ton of improvements that we're going to see, and I really think part of the reason that I wrote this book on legal informatics and technology is people have to get used to using it, and it's going to completely transform the profession. I think all of us want to see, even within mediation, that the mediators are spending less time per client and applying technology, and yet overseeing the quality and making sure that whatever numbers we have jive with our subjective experience of what we want to see.
That's a great point. I agree with that 100%. Hiro, what were you going to say?
I guess my question was about who owns the AI? Is this all open source? Because you can imagine a world, 10, 20, 50 years from now when we have robot mediators and arbitrators and judges and lawyers are churning out briefs using ChatGPT. Who owns the proprietary rights to that AI? And are we not headed towards a world where justice becomes commodified and is, justice of the corporation that owns that, I guess, IP, right, underlying the AI? What's being done to kind of prevent that dystopic future that we might be facing?
Do you have thoughts about that?
it's all well and good to use this technology, but who is calling the shots? Who's going to be selling this to us? Who do we have to buy it from? Who's going to restrict access to some people to get this technology and not? I mean, that seems like it would open up a whole can of worms in terms of issues that we need to.
Well, I want. Let
Absolutely.
me
Absolutely.
Do you want to respond? To that?
I'll just say that I think it's the horse is already out of the barn, and I think is my sense. And so litigation, a public process, according to age-old laws, may be the initial process trying to sort this. It's probably partially what's behind Elon Musk's pause button in terms of these developments. But I think it'll be very difficult to sort out. And it doesn't stay in its jurisdiction. As you said, it's across jurisdictions around the world. So I don't know how it's going to be clarified.
Yeah, I mean, I'll tell you my opinion. I don't think this is going to be like one all-seeing eye of Mordor at ChatGPT, and we all kind of come up and offer our burnt offerings and say, what's the outcome? I think we're going to see an endless flowering of AIs. I think we're going to have AIs everywhere. A bunch of these Stanford students, they recently took essentially an LLM, and you can run it on your desktop at home. We're all going to have our AIs that we can go consult. And different people are going to train them in different ways. We in the ODR field are going to take a bunch of dispute data and educate, our algorithms. And, it could, that's why I'm saying, I think if we empower agents to negotiate our cases, crowdsourcing is a possibility here. We may have 100 different AIs that can hear a case over $50, and you'll have one from a Consumer Protection Bureau, you'll have another one from the Chamber of Commerce, you'll have another one from Hastings, you'll have another one from Stanford, and then you decide and you put together an assemblage, and they all listen to it, they all render decisions. Whoever gets a majority of the AIs to agree with them, they win the case. And you could do this for a $10 dispute, because all these things operate 24/7, like the Daft Punk song. Our work is never over. It's just 24 hours a day. They're just cranking out resolutions. That's just one possible future. But I think this notion that somehow there's going to be one centralized and all the data is going to be there. When I first started doing ODR, there was a big digital divide problem. Only rich people had technology. So if you deliver a justice system over technology, you're delivering a justice system for rich people. Well, now what's happened? You can get a pretty good phone at the drugstore for $30, and now 98% of people in the United States access the internet on a daily basis, the vast majority through their phones. So now we have a new digital divide. You have rich people that get access to this very powerful AI technology. And you're going to see that where the corporations are using this stuff at scale, and then individual consumers, they don't benefit from this technology, so they're kind of left out in the cold. So we have to figure out a way to rebalance the equation. But eventually everybody's going to have access to this. Now that Microsoft has open sourced, OpenAI, I logged into Skype the other day, and there was a message from Bing. Hey, if you have any questions, ask me. I go into my browser, and there's a button, and I can ask Bing. I think this technology is going to be democratized very quickly.
Won't the access be controlled by the owners of the AI, right? I mean, they could charge more than most people could afford. There are issues about,
Absolutely.
who it's available to and who can afford to use it and so on. So I just wonder about this. So are there different companies that are setting up different AI platforms and then charging the users of that AI now?
It's a good question, but a lot of these AI mechanisms have been open sourced. So you see, it used to be DALL-E was the only image generator, and then Stable Diffusion got it and open sourced it. It used to be that ChatGPT was the only large language model. Well, now these Stanford kids, they created Alpaca and they've created Vacuna, and it's all open source. You can download it and install it on your own computer. So I think, in a sense, the dynamics of technology are radically flattening access, and that's something that you see with these new technologies. They start out very expensive, and then they get widely applied if there's demand. Ron, I saw your hand. What did you want to say about all of that?
I just want to, I've talked about like an e-bar. So, we don't know which lawyer to go to, and when we try to pick a lawyer, it's like, well, who did you like, or, whether it's family law, who did you work with? If it's a corporation, it's like maybe you want to look at win rate, which may or may not relate to the quality of the work. And we just think that once law students have passed the bar, then they are ready to practice and they can do what they want. And the only thing we know or that we track would be negligence or complaints to the bar. I think with software, we want to have the equivalent of some sort of certification process, and that software would be only allowed to operate if it passes a certain level of examination.
Yeah.
Including in that is triage that says I can only handle cases, up to this amount or with this complexity or, this kind of custody. I can't,
So are you proposing a bar exam for AIs?
I think that we get used to certification. We're used to something like a good housekeeping seal.
Yeah.
And what happens is that our trust goes to the certification company like UL for electronics.
Yeah.
And
Yeah, they do that with dishwashers.
Remain neutral in the process. And so long as, we want a robust competition among some of these AI vendors. And what we want to make sure is that we're maintaining some sort of reasonable quality in terms of fairness or bias or, however we're looking at it.
That's an
And
interesting
at the
idea.
end of the day, we want to tune to metrics. And I keep saying that industry needs to set standardized benchmarks that we want an industry to tune to, like with CPU or with memory.
Right.
And I believe that we want to do something similar. If you're handling immigration or family law or whatever, we want to make sure that you can handle a certain complexity with a certain type of sufficient result.
That's an interesting idea.
So anyway.
What does everybody think about that? Do you want to have a bar exam for AIs? Yeah.
I mean, I have a huge problem with that, actually, I think, because it's what we sort of talked about already before. It's turtles all the way down. Right? It's like literally we're stacking the same flawed reason. And not to like completely, I don't completely
I'm not trying to specify what that exam might look like. And I'm not saying it should mirror what we're doing now, right?
But humans
It's
build the
setting
stuff,
a minimum
and humans are flawed,
threshold that
so
if
the
you-
stuff's going to be flawed. I
If you
think that's-
can't at least pass these questions, you have no business serving people directly. And you got to look at it. It's kind of like a minimum quality standard, or we do not want to allow that software to touch people.
I like the idea, and it's an intriguing concept to think about. How would we create this exam, and what questions would we be on it? But I actually do disagree with humans are flawed. We're going to build this technology. The technology is going to be flawed because we're flawed. Because I do think that there is the potential for this technology to exceed our own ability. It can do things that we can't do. And I think we can observe the outcomes. We can look at the procedure of the process and say, okay, this is procedurally just. And looking at these outcomes, as Ron's talked about, there are objective metrics around fairness. And we look at these outcomes and say, wow, it's delivering fair outcomes, And how is it doing that? It's doing things that we can't understand. It's beyond our ability to comprehend. Maybe if we had a camera that was watching a witness and it's watching the temperature changes and listening to their voice inflection, and maybe it gets to the point where it can detect whether or not somebody's lying to like 98% certainty, and humans can't do that. Is that better? If we're trying to evaluate the credibility of a witness and computers can do that, why wouldn't we leverage a technology to do that? It exceeds our own abilities. So I'm not sure it's turtles all the way down. I think what we do with that data is going to be flawed because humans are flawed. But I still think that technology, if you look, this is my final rant, I promise. But I have so many rants that I want to do. If you were to take a baby out of Elizabethan England and drop them into a high school in Milpitas, by the time they graduated, they look like everybody else. Humans don't change. Our biology does not fundamentally change that much. What is it that changes about history? Technology changes. Somebody invents the printing press. Somebody invents gunpowder. Somebody invents technology changes, and you can't unring the bell. That's what makes the difference between the high schooler in Shakespeare's time and the high schooler today, is the technology is different. So I think that there is a fundamental change here, and we got to figure out how to utilize it, because all technologies, they have upsides, they have downsides. So we have to do everything we can to minimize the downside and to leverage the upsides. But I don't think it's turtles all the way down.
On that note.
Oh, really? That's the final word? Oh, my gosh. Okay.
But I just want to thank you both for joining us. This was really a terrific conversation. So let's give them a round of applause.
Thank you.
The reception, there's food and drinks.